Dear participants, dear colleagues, my name is Roman. I work as a project coordinator at the Center for Civil Liberties, a Kyiv-based think tank that last year received a Nobel Peace Prize for 2022. And today, in the framework of Соціал обов'язкові project promoting internet freedom in Ukraine, we are conducting a series of webinars on the topic of media law, ICT law, and other related topics. Our other webinars are available on our YouTube channel, and I for sure will share them with you. Today, we have an important topic for Ukraine. As you know, Ukrainian government and Ukrainian people declare interest to become a part of European Union. And after Ukraine has been granted the EU candidate status, Ukrainian parliament, Ukrainian legislator should adapt our national, local, state legislation to the best practices of the European Union. And this webinar is the opportunity to discuss one of such legislative acts. In the past, we were speaking about GDPR. We were speaking about European Union cybersecurity regulation, NIS1, for example. We already get acquainted we already get to know European Union freedom of speech standards. And we also speak about relevant draft proposals, such as NIS2 or European Media Freedom Act. Today, our speaker, our guest, Ms. Donatella Casaburo, will speak about European Commission regulation, a draft proposal on artificial intelligence. Ms. Donatella is a researcher at the Leuven University Center for IT and IP Law in Belgium. Previously, she worked on several European research projects dealing with artificial intelligence, cybersecurity, and fundamental rights. She holds a cum laude advanced LLM degree in IP and ICT law from Leuven University in Belgium and cum laude master degree in law from the University of Trieste in Italy. Currently, she is a doctoral researcher at Leuven University Center for IT and IP Law. I will be your moderator today, and I will be happy to receive your question in the chat, or you can ask them directly to Ms. Donatella at the Q&A session at the end of the webinar. Donatella, the floor is yours. You can share your screen now.
Thank you very much, Roman, for introducing me, and thank you everyone for attending this webinar today. I'm very happy to see that there's a lot of participation, and I hope there will be a lot of interaction as well. And first, also, I would like to thank Roman and the Center for the invitation. I'm very happy to join you, and I'm a very big supporter of the cause of the Center, so I'm happy to be here today. So I will start sharing my screen now, so we can start with the presentation. Can anybody please confirm me that you see my screen?
Yes, correct. Thank you.
Okay, perfect. So today my presentation will deal about the European Artificial Intelligence Act, which is the regulation which was proposed by the European Commission, and I will focus more specifically on the field of law enforcement. This is directly linked to my research project that you see here in the slides, which is called Aligner. Aligner is an Horizon 2020 project, so we have received funding from the European Commission to basically build different stakeholders advisory groups, discuss with them about the capability needs of law enforcement agencies. And then our output is research roadmaps that the European Commission then can use for informing the future research about artificial intelligence and law enforcement. So far, we have reached month 18 of the project, so we're halfway through. We have delivered, as work package on legal and ethics, we have delivered our first output, which was the mapping exercise of the different legislation that is applicable to the use of AI in the law enforcement domain. And I am about to deliver the second output, which is a human rights impact assessment template for law enforcement. They are intending to use AI tools in their daily tasks. So this presentation is based on my previous research when I mapped out the legal requirements that the law enforcement agencies have to observe while deploying artificial intelligence tools. So this is the outline of today's presentation. I will start with a very, very brief introduction on what AI is, and then I will explain some possible applications of the AI in the law enforcement domain and some possible human rights concerns. And then I will present the proposal for an AI regulation. So let's start from a general introduction on what we intend with AI. Well, artificial intelligence is not a new concept. It was theorized, one of the first theorization dates back to 1950, when Alan Turing published his Computer, Machinery and Intelligence. There, Turing proposed the idea of the very famous imitation game, which is also famous under the name of Turing test, which is a test to determine whether a machine could imitate human intelligence. As for curiosity, this is how visually the Turing test looks like. Basically, what Turing proposed was to have a human evaluator that would judge natural language conversations, so normal conversations between a human and a machine that was specifically designed to generate human-like responses. The evaluator would have been aware of the fact that he was interacting with both another human and with a machine, but was not aware, of course, of which one was the human, which one would it be the machine. And all of them were separated, so there was no way of understanding who was speaking with whom. So they were carrying on this conversation. This conversation would be limited only to text, to written texting, so that there was no problem for understanding speeches related features. And the Turing test was passed if the evaluator couldn't say who was the machine and who was the human. This is currently used, let's say, to evaluate machines. And so far, no machine has ever passed the Turing test. Just small curiosity to understand how this concept is not a new concept, but it was theorized long ago. What do we mean now instead in current times with artificial intelligence? Normally, we say that artificial intelligence is an area of computer science that deals with giving machine the ability to seem like having a human intelligence. Well, this doesn't say that much. Another possible definition is the power of a machine to copy intelligent human behavior. Again, it's a very broad definition, doesn't say that much about the characteristics of artificial intelligence. More complete definition could be the fact that the artificial intelligence normally has the ability to act purposefully, think rationally, and deal effectively with the environment. One attention point here is that this is an evolving concept. That means that when we get used to the fact that a machine can do something, then we don't call it intelligent anymore. In the collective imaginary, we think about AI as what is known as general AI. So a machine that can successfully perform any task in any context. For instance, we might think that artificial intelligence has some characteristic like consciousness, self-awareness, sapience, emotions, and so on. And this is a bit the idea that we get from movies, for instance, Hair, Blade Runner, AI. But actually, we have to say that this is a myth. So general AI is not achieved right now. It is difficult to achieve. What we instead technically intend with AI is narrow AI. So machines that are designed to perform one single task in real time. What is mostly used right now is machine learning. Machine learning is a subset of AI. That means that it is an algorithm that has these characteristics: improve automatically its performance on a specific task through experience and using training data. So this is what we intend now, and then we will intend for the next part of this lecture with AI. When we think about machine learning, we have to think mostly about pattern recognition. So a machine that is very, very good at identifying patterns in a subset of data. So how can we use instead artificial intelligence in the law enforcement domain? Law enforcement domain maybe needs in itself some clarifications. So what we mean with law enforcement domains, first of all, we refer to competent authorities. These are public authorities or bodies or anyway entities that were entrusted by member state law, member state of the European Union to exercise public authority and public powers. And these competent authorities have to act for a law enforcement purpose. These law enforcement purposes might diverse, so prevention, investigation, detection, or prosecution of criminal offenses, and execution of criminal penalties. So when we have these two characteristics, so competent authorities and law enforcement purposes, then we are speaking about law enforcement domain. Some examples now of how AI can be used in the law enforcement domain. For instance, digital forensics. AI is widely used from law enforcement agencies to identify, detect, extract, and analyze digital evidence. And here I listed one example. For instance, an example I found interesting is the one of steganography. So basically what happens is with steganography techniques, a secret image or a secret information anyway can be hidden behind a cover image or a cover information. So this is of course highly used by criminals to hide secret informations that they want to exchange, and AI can help LEAs in detect and contrast steganography. Another example, also in the law enforcement domain, but different from digital forensics, is that of predictive policing. Predictive policing is that area of science that aims to predict what individuals or what geographical areas have an increased probability of criminal activities. So law enforcement agencies can better develop their police intervention strategies and tactics. And here, again, I have another example of AI, how AI can help law enforcement agencies while they are conducting predictive policing activities. For instance, law enforcement agencies can deploy algorithms to assess the criminality of 12-year-old children based on existing police data about these children. For instance, reports in which the police was explaining how these children have come in contact with them, or their address, or information about their living environment, on whether they are victim or violence. Another field in which AI can be used to help law enforcement agencies is, for instance, that of biometric identification. So biometric identification aims to identifying natural persons at a distance through the comparison of a person's biometric data with the data that are contained normally in a reference database. An example of an algorithm that can be used by law enforcement agencies is an algorithm that aims to detect, localize, and analyze sperm cells for identifying suspects of sexual crimes. So here I have reported a bit the fields. Well, these are not, of course, all of them, but these are just examples and examples of algorithms. We go from something that is harmless, let's say, if used by law enforcement agencies like steganography or the detection of sperm cells. But we can also see that there are possibilities for law enforcement agencies to also interfere with the fundamental rights of individuals. For instance, when they are profiling 12-year-old kids, or when they are using their biometric identification tools for crowd controlling and so on. So an important perspective that has to be taken into account is the fundamental rights perspective. Here I listed the 5 fundamental rights that are most likely to be infringed by the use of law enforcement, by the use of AI systems from law enforcement agencies. And these are the presumption of innocence, the right to a fair trial, the right to equality and non-discrimination, the freedom of expression and information, and right to privacy and data protection. So these 5 rights were my benchmark while conducting my research. And here I will just explain them very briefly and give you an overview of the possible infringements. So we start with the presumption of innocence, right to an effective remedy, and right to a fair trial. Just a brief recap of the right. So everyone charged with a criminal offense must be presumed innocent until is proven guilty according to law. Everyone whose rights and freedoms are violated has the right to an effective remedy before a tribunal, and everyone is entitled to a fair and public hearing within a reasonable time by an independent, impartial tribunal that was previously established by law. So these are the characteristics, let's say the components that are substantiating the presumption of innocence, a right to an effective remedy and to a fair trial. And these different components might be endangered when law enforcement agencies are deploying AI tools. For instance, AI tool might be targeting individuals without solid evidence. So based on the output of the algorithm can be used by law enforcement agencies, for instance, to press charges, even though that output is the only indication that the suspect has committed a crime. This might lead to a reversal of the burden of the proof, which means that a subject, instead of being presumed innocent until proven guilty according to law, is assumed to be guilty because the algorithm has flagged this. Moreover, especially when we think about algorithms that have to be that are a bit more difficult to explain. So let's say the problem, the problem that's famous as the black box problem. Whenever an output is not easily explainable, the decisions are particularly hard to challenge for the defendants in court. What about the right to equality and non-discrimination? The right says that everyone is equal before the law, and any discrimination which is based on grounds such as sex, race, color, ethnic or social origin, genetic features, language, religion or belief, political or other opinion, memberships of a national minority, property, birth, disability, age, or sexual orientation has to be prohibited. What might happen is that an algorithm is targeting specifically the member of a social group, thus infringing the right to equality and non-discrimination. It might happen that biases are perpetuated and reinforced by the algorithm. Of course, humans are biased. That's an argument that I hear a lot. Humans are biased, but the algorithms have an increased potentiality of reinforce and perpetuate already the biases that are embedded in the humans. The third right is the freedom of expression and information. So everyone has the right to freedom of expression, including the freedom to hold opinions, the freedom to communicate, and the freedom to acquire information. In this case, this right can be endangered. For instance, if minority groups are targeted specifically, or whenever an AI tool is anyway impacting the freedom of expression and freedom of information, minority groups may be suffering chilling effects because they maybe don't want to expose themselves anymore. Also, the data that are recorded and stored and produced by the algorithm might not be easily accessible, thus violating the freedom to acquire information. Last, oh, sorry, this title is wrong. I was a bit confused. The title is wrong. No, we are speaking here about the right to privacy and data protection, which says that everyone has the right to respect their private and family life, home and communications. Also, this right can be endangered by the use of AI from law enforcement agencies whenever the processing of data is not carried out on the basis of a specific legal basis, or whenever the data subject rights cannot be guaranteed sufficiently. And lastly, especially whenever there is bulk retention of data, there might happen power asymmetry and mass surveillance. So for a bit trying to put a remedy also to these possible violations, the European Commission has decided to try to regulate artificial intelligence via the means of the famous AI Act. The AI Act is not the only possible means for regulating and putting a limit to our artificial intelligence. We have an already existing legal framework that can be applied. At the basis of this legal framework, as we have already seen, we have the fundamental rights. And from the fundamental rights, there are pieces of secondary legislation that are stemming from that and that are very relevant. For instance, the right to data protection, the data protection legislation, the regulation on the free flow of personal data, and the directives that are concerning the procedural rights of the suspected and accused persons. So here we can visualize a bit more the secondary legislation and basically understand how many pieces of already existing and already adopted legislations can be applied to regulate the use of AI. For instance, data protection legislation is, in our case, which is focused on law enforcement, is primarily focused on the law enforcement directive, but also the e-privacy directive is relevant, and the Europol regulation. The regulation on the free flow of personal data and the directives that are concerning procedural rights of the suspect and accused persons. So these are all pieces of legislation that are suitable to mitigate some risks of the use of AI, but there's currently no horizontal piece of legislation that is regulating artificial intelligence. By horizontal, I mean a piece of legislation that takes care of regulating all the aspects of artificial intelligence. And that's not, for instance, related to one specific of them, like data protection. Sorry, I think there's a problem with the sharing of the screen. I will try.
Yes. Can you try to share it again? It was log out.
Yes, I'll share it again. Sorry, I don't know what happened. It's a pity because I was reaching an important point. Okay. Oh. Do you see my screen now? But do you see it from the beginning, right?
Yes, please go to your slide. Yes.
It will take a while.
Of course.
Unfortunately, there were so many animations.
But it makes us easier to understand your point. Thank you for that.
Okay, we're almost there. Okay, so there's no horizontal piece of legislation that's regulating artificial intelligence yet. So we have already mentioned the AI Act. So So the AI Act doesn't, of course, come out of nowhere, but the Commission has invested a lot of resources in the last year to try to settle a framework for the use of AI tools. So in 2019, the Commission entrusted the high-level expert group on artificial intelligence to draft some ethics guidelines for trustworthy AI. And this document from 2019 was the basis for another document the Commission itself published, so a white paper on artificial intelligence, on a European approach to excellence of trust. And together, these two documents are basically the basis for the AI Act. Here visualized, you see a bit how these documents are organized. So we first have 4 ethical principles that have to inform the development and the use of AI, artificial intelligence in general. And these are human autonomy, prevention of harm, fairness, and explicability. These 4 ethical principles are translating then into 7 key requirements. That are human agency, robustness and safety, privacy, transparency, fairness, societal well-being, and accountability. Altogether, they have to be implemented according to a risk-based approach. So what is the AI Act proposal doing now? So it was published in April 2021. It is still under discussion. So the 2 co-legislators in the European Union, so the European Parliament and the Council, are now in the trilogue phase. So they are discussing about the amendments, and we hope to have a more finalized text towards maybe the end of the year, hopefully. So the regulation, it is a regulation, and if you are familiar already with European law, you know the relevance of this. But if you're not, it is the relevance of having such a legal act. It is that it is a binding act, which is directly applicable to member states. That means that no national transposition is required. So the AI Act, as it is, will have to be implemented already in the member states without having the need to have a separate national act. As legal basis, the AI Act uses 2 different articles on the Treaty on Functioning of the European Union, which is Article 114, which regulates the establishment and the functioning of the internal market. And Article 16, instead, it's basically giving some indications on how the processing of personal data and free movement of such data should happen. This is reflected, these 2 legal bases are reflected in the objectives of the AI Act. The first objective is ensuring that all the AI systems that are placed and used in the internal market are safe. So this shows how the AI Act is basically trying to transpose the traditional product safety legislation of the European Union, also with regards to AI tools. And the second objective of the AI Act is ensuring that the AI systems that are placed and used on the internal market are respecting fundamental rights. As I mentioned before, this is an horizontal regulation that is applying to all the AI systems in all sectors. The regulation proposes a definition of AI as a software that, for a given set of human-defined objectives, generates outputs, which might be content, predictions, recommendations, and so on, outputs or decisions that are influencing the environment the system is interacting with. This software has to be developed with 1 or more of the techniques that are listed in the Annex 1 to the regulation. The first one is machine learning, the one I mentioned before, but we have other different techniques, for instance, logic and knowledge-based approaches or statistical approaches and so on. What is clear of this definition that it is extremely broad. with the aim of being technology neutral, so that all the future possible applications of AI will be regulated as well without the need to amend the regulation. So for what concerns the material scope of application of the regulation, so two categories of subjects are included: providers. The providers are the natural or legal persons that are developing an AI system with a view to place it on the market or putting into service under their own name or trademark. And it doesn't matter if they are actually getting paid or not for this service. And the second category of subjects is users. So natural legal persons that are using an AI system under their authority, except where this AI system is used in the course of a personal non-professional activity. So these are the two categories that will have to observe the AI Act. And for what concerns instead the territorial scope of applications, again, it is divided among the two categories. So for what concerns providers, the providers can be established in the European Union, or they can be also established in a third country. But if they are targeting the internal market of the European Union, or if the output is used in the European Union, they will also have to observe the AI Act. For what concerns users, instead, again, we have users that can be both located in the European Union or in a third country, but the output has to be used in the European Union somehow. There are some exceptions to this to the scope of application. For instance, the AI systems that are developed or are used exclusively for military purposes, or public authorities that are located in third countries or international organizations if there are already international agreements for law enforcement. The AI Act is based on a risk-based approach, which starts from the assumptions that not all the AI systems are the same, but the risks that are generated and the harm that might be caused, it depends highly on the circumstances of application and the use that is made of the system. So that means that the content of the obligation is different and is based on a sector-by-sector and case-by-case approach, and takes into account the intensity of the possible risks that are generated. So the AI Act divides the AI systems in 4 different categories of risks: unacceptable risk, high risk, limited risk, minimal risk. Starting from the first category, so unacceptable risks, the AI systems that are contravening the EU values by violating fundamental rights are to be considered carrying on an unacceptable risk. So the AI Act, it identifies 3 categories of systems that are that have an acceptable risk. The first one is manipulative system, second one is social scoring, and the third one is real-time remote biometric identification. So what is the consequence of being considered, a system being considered as carrying on an unacceptable risk? Systems are prohibited. So the first category is the manipulative AI system. The AI Act differentiates 2 different types of manipulative AI systems. The first one is systems that are trying to deploy subliminal techniques beyond a person's consciousness. And the second one is instead a system that's trying to exploit the vulnerabilities of a specific group of people, vulnerability that might stem from their age, physical or mental disability. Either of these categories have to be used with the aim of materially distort the behavior of a person or cause physical or psychological harm to that or another person. An example, since it's not straightforward, an example, for instance, can be a doll, which has this integrated voice assistance that is encouraging minors to engage in dangerous behaviors. Second category of prohibited AI system is social scoring. So AI systems that are used by public authorities for the evaluation of trustworthiness of natural persons based on their social behavior or known or predictive personal characteristics. With social scoring that's leading either to an unfavorable treatment in a social context that is unrelated to the context in which the data were originally collected. This is known as the same context exemption. So if the system is used in the same context, that is not prohibited anymore. Or another consequence of this system, this social scoring system, can be an unfavorable treatment that is unjustified or disproportionate to the social behavior observed or its gravity. An example can be a system which is identifying at-risk children in need of social care based on insignificant or very relevant social misbehavior of the parents, for instance, not showing up at a doctor's appointment or having a divorce. The third category of prohibited AI system is instead that of real-time remote biometric identification, and this is for sure the most famous one, most debated one. So here I tried to unpack a bit the provision. So real-time remote biometric identification systems have to be used in accessible spaces for the purposes of law enforcement. That is the definition of the AI Act. So what is an identification system? So it is a system that is designed with the purpose of identifying natural persons at a distance by matching their biometric data with those contained in a reference database. We have already seen this. The system has to be used in real time. So this identification process, from the moment of collection of the data to that of the identification, has to occur in real time or without any significant delay. This system have to be deployed in a public accessible space. So it is a physical place that is accessible to the public. And they have to be used for law enforcement purposes. So the one we have seen already, prevention, investigation, detection, and so on. Example is your cameras that are capturing live the faces of individuals that are then all the faces of the individuals, and these faces are then checked in real time against a database of suspects or identified terrorists. So these were the components of the definition. Some clarification. So the prohibition applies to AI systems that are placed on the market, which means that EU vendors can sell these identification systems to third countries. It's very famous, the case of EU producers and selling these systems, for instance, to China. The prohibition applies to real-time identification. So that means that post-identification systems are not prohibited, but then we'll see in a few minutes that it is considered to be high risk. The prohibition does not apply to actors that are using remote biometric identification for non-law enforcement purposes. In this case, if a real-time remote biometric identification is used for other purposes than law enforcement, then its use is only subject to compliance with the GDPR. If the definition was already not broad anymore, we have also 3 exceptions to this general prohibition. For instance, remote real-time biometric identification systems can be used for the targeted search of victims of crime, including missing children. Can be used for the prevention of a specific substantial and imminent threat to the life or physical safety of natural persons, or in case of a terrorist attack. And then can be used for the detection, localization, identification, or prosecution of a perpetrator or a suspect of criminal offenses that are allowing the issuing of a European arrest warrant. If you're curious about this last provision and how many are these criminal offenses, here you have a list. So it is clear that this exception to the prohibitions are very, very broad. For applying these exemptions, however, 3 conditions have to be complied with. The first one, the use has to be strictly necessary. There must be compliance with safeguards, for instance, limitations in terms of time or geographical scope or personal scope of the use. And there must be a prior authorization that has to be granted by a judicial authority or anyway an independent authority. However, in duly justified situation of urgency, the use of the system can be commenced without this authorization. The authorization can be requested ex post. This was everything for the first category of AI systems carrying an unacceptable risk. Second category that was identified by the AI Act was the high-risk AI systems. So these AI systems are the AI systems that are posing significant risks to health and safety or to fundamental rights of persons. Health and safety, again, is the product safety legislation soul of the regulation. So the first category of AI systems, high-risk AI systems, is that of AI systems that might cause severe risk to health and safety, which are basically AI systems that are covered by the product safety legislation and that have to go under third-party conformity assessment. More relevant in our case is that it's represented by those AI systems that are listed in Annex 3 of the regulation. What is the consequence of being considered a high-risk AI system? These AI systems are permitted, but they are subject to specific requirements, and they have to undergo through a process of ex-ante conformity assessment. As I mentioned, the categories that are included in Annex 3 is the one mostly relevant for law enforcement. For instance, biometric identification and categorization of natural persons, including real-time and post-remote biometric identification, is considered as high risk. Law enforcement in general is considered as high risk, whatever the kind of tool is used. Migration, asylum, and border control is considered high risk. And the last one relevant here is the administration of justice and democratic processes. So I said these applications are allowed, but they have specific requirements that are stemming from the risk-based approach. So for instance, risk management. During the life cycle of the AI system, there must be this risk evaluation with the view of mitigating the risk. Data and data governance. There are specific standards for the quality of data sets that have to be relevant, representative, free of errors, which is a bit tricky, and complete. Technical documentation and automatic recording of events. These have to be has to be drafted and kept. Transparency obligations, so to enable the users to understand the output and explain it. Human oversight, so the individuals must be able to understand this output, explain it, monitor the functioning of the AI system, and they have to take the final decision. So they have to be able to disregard the output. And the last requirement is related to accuracy, robustness, and cybersecurity. So the system has to be specifically resilient against errors or inconsistencies or attacks, cyber attacks. These are all obligations for the providers. Also, the provider has to take care to conduct this anti-conformity assessment. So it is a procedure that's aimed at establishing the product safety of the AI system. So it verifies the compliance with the requirements I just mentioned. So this is a bit the thought process. So whether we have to evaluate if this AI risk system is applying these standards, if common standards, if the AI systems applies standards, then the control can be performed already by the provider. If the AI system is not applying standards, then there must be an external control. And the outcome of this ex-ante conformity assessment is the possibility to affix the CE mark on the product, which is, of course, testifying the fact that there's compliance with requirements. Lastly, third and the fourth risk categories, limited risk. So these AI systems that are intended to interact with natural persons, like for instance, chatbots, they only have to comply with minimal transparency obligations. So they have to be, they have to make clear to the humans interacting with them that they are interacting with an AI, unless it's of course obvious. And the last category is the category of AI systems with minimal or no risk, for instance, video games and spam filters. And this can be freely used and developed. That was everything. I hope it was interesting for you. And I'm here for any questions you might have.
Dear Donatella, thank you first of all for being on time and delivering your presentation in 40 minutes, and of course for your well-prepared PowerPoint presentation. We have received several questions in the live stream, and if I'm allowed, I will read them aloud one by one. And the first question is, in what cases it is already prohibited to use AI in a legal context?
So this is a bit of a tricky question. The idea is that the AI Act will have some, as I mentioned, will have some systems that are considered to be prohibited. And in that case, we will have prohibited AI systems that cannot be used. Now, there are no prohibitions in itself. So what happens is that the whole European legal framework that I mentioned previously, so for instance, data protection legislation, human rights, data protection, and other pieces of legislation related to the procedural rights of individuals and so on, have to be applied. So the use of AI systems might be scrutinized on the basis of those pieces of legislation. So there's no prohibition, ex-ante prohibition, but these pieces of legislation might be used to enforce some human rights and then to constrain the ability of law enforcement agencies to deploy some AI tools. And this is happening. This is happening, for instance, a lot in the Netherlands, where police authorities are very public and they're very transparent on the AI systems that they are using. And they are explaining to the public and to the political institutions how these systems were developed, how they are using these systems. And sometimes these systems then are judged by the national courts, and their use is prohibited. So in a nutshell, there's no really currently a prohibition for specific AI systems. It will come. But nevertheless, this can be scrutinized and prohibited afterwards.
Understood. Thank you. And before we move further, I will remind the participants that indeed our webinar will be recorded and will be put online on YouTube, and you can revisit certain points of the presentation. But feel free to use this possibility to ask interactively the second question. In the meantime, I will go to the chat and ask another question. Are you aware of real cases of AI use in legal practice and human rights protection?
So, for instance, all the cases that I mentioned at the beginning of my presentation, so for instance, steganography or sperm detection or algorithms assessing the likelihood for 12-year-old kids to commit crimes, all these examples are based on real cases. So these are either tools that are being developed, for instance, by European projects, or the legal tools that or AI tools that are anyway used already by law enforcement agencies. What I have seen so far is that most of the AI tools are used, for instance, in border control or in digital forensics. So to monitor the access from third countries or to collect and analyze digital evidence. But there are also some predictive policing tools that are used already, and this is always increasing. So I'm seeing every day many Horizon projects, so funded by the European Commission, developing new tools, new solutions, and these are then not all of them, but some of them they are used then afterwards by law enforcement agencies. So there is a lot. It is also a bit difficult having really having let's say an overview of what tools are used by who, because this is of course a matter of internal security, so not everything is extremely public. But there are some reports that are listing the tools used in different countries of the European Union. As for the human rights protection, well, especially when these tools are developed within the, let's say, with European funds, so they are funded by the European Commission, human rights protection is already embedded in the system because these projects are heavily scrutinized from a legal and ethical point of view. So in this case, there is, let's say, during the development phase, there is a lot of compliance that is already ensured. Of course, that doesn't mean necessarily that the same human rights compliance is then translated in the end use. For the end use, then it's up to the courts, the national courts, to scrutinize the tools. And as I mentioned before, this is happening. It happens, for instance, it has happened a couple of times already in the Netherlands, and then I'm not aware of every jurisdiction in the European Union, but I'm sure this is happening elsewhere as well.
Thank you for your answer, and I will also elaborate a little bit more that in the context of Russian invasion of Ukraine, AI capabilities can be used and are used for the investigative purposes, because AI is able to analyze a big amount of open source data, and it is indeed very helpful for perpetrators tracking, for finding war criminals. And also such investigative journalist groups as, for example, Bellingcat and others are able also to use AI tools for open source analysis. Yes, and let me check the translation chat. Okay, the last question. On your personal opinion, based on your experience, what are the pros and cons of the use of AI for law enforcement purposes, privacy, and the use of AI in law enforcement? Thank you.
That is interesting. So AI is incredibly useful for automatically carrying on all these tasks that normally were carried on by police agencies manually. For instance, in the field of digital forensics, AI tools are incredibly incredibly useful because they can analyze digital evidence much faster than a human could do, and they can really help in solving a lot of cases. So in that case, I see I'm very much in favor of deploying AI solutions. What is to me a bit more tricky is, for instance, the case of biometrics and also the case of predictive policing, because these are not related to a specific crime scene. These cases like remote biometric identification and also predictive policing are not linked to some crime happened and they are not trying to solve a crime either. They are trying to identify potential suspects in a crowd, or they are trying to identify the likelihood of a crime to be committed. So in these cases, I think from a human rights perspective, they are a bit more tricky. In the case of remote biometric identification, for instance, there's a huge risk of mass surveillance, especially in the case of real-time remote biometric identifications. The faces of everyone is recorded and scrutinized against a database. This is not the case in post biometric identification, for instance, but we have to take into account the possible risks and possible chilling effects that are coming from that in terms of mass surveillance and power asymmetry and so on. Predictive policing, I think, is another case of very, very tricky application of AI systems, because in that case, we are evaluating the likelihood of a crime to be committed either from a person or in a geographical area. For doing this, we have to collect a very big amount of data for the predictions to be accurate. And also another problem is, how do you evaluate accuracy of the predictions? Have these tools been tested for what concerns their effectiveness, their reliability? That's also another problem. I think, for instance, in the case of predictive policing, whenever they are tested and their effectiveness is proven, then they can be beneficial for law enforcement agencies. But again, even in this case, I see a lot of problematics in terms of human rights protection. So I don't think, as some people are advocating, like AI tools shouldn't be used by law enforcement agencies. I think what they should be used for an internal security perspective, but what also should be very much taken into account is the human rights perspective, and this should be implemented in the research and development stage and should be constantly checked in the use stage instead.
Donatella, thank you for your answer, and I would like to facilitate the last question for you. Can you comment on the use of AI for the execution of punishments? And it is indeed the biggest question for our webinar, because when we speak about criminal justice system, we speak about human life and human suffering. And as we know, law enforcement and criminal justice authorities are relying and using artificial intelligence and something that's called ADM, automated decision-making system. And this system is used to profile people, predict their actions or predict their behaviors, and assert the risk of certain behavior. So they are believed are able to determine and identify certain negative patterns of person behavior. But as Donatella mentioned, every person have a right to a fair trial and have a right to not be charged guilty without due process. And when we speak about criminal justice and AI, we should be very cautious. And I can elaborate that after hearing Donatella's presentation, for example, European Union have this AI Act regulation, have this proposal that is should deal with such problems, should create relevant safeguards of any negative consequences of using AI. But for example, in United States, the market is a little bit like Wild West, and I can assure you that this is a big question, and it will be a big question for decades to come. But Ms. Donatella, if you want to elaborate more, the floor is yours.
I completely agree with you. I think it's a matter of understanding whether, first of all, whether a system has to be used in that specific circumstances, and if considered to be used, how to implement the safeguards in the design stage and in the use stage. I think there's no black and white answer to this. Everything well, I'm very sad to give the typical lawyer answer of it depends, but it depends how the system is used. What I know is that whenever a system is used in law enforcement or execution of penalties, these are very sensitive domains. So a specific attention should be paid to the rights of the individuals involved, because also one violation is an important violation. So in this case, it's not a problem of exposure. Let's say how many people are affected, but it is a question of severity of the impact then on the people affected. So it is a sensitive domain. Safeguards have to be implemented. We're lucky that in the European Union, we are trying to regulate this via the AI Act, but we also have, let's say, an ethical tradition in how to develop these tools. Because as I mentioned, the AI Act doesn't come out of the blue. It comes from something that was already done in the previous years, that was already advocated for in the relevant spheres, but this cannot be said for every country. So then it depends a bit on the jurisdiction. But again, I think the idea is let's deploy the tools that are worth be deployed, as long as we are also deploying a lot of safeguards.
Ms. Donatella, thank you for your time, and thank you for your excellent presentation. And dear guests, every registered participant will receive tomorrow a follow-up letter with all relevant links to further readings on today's topic. And on this note, we are done for today. Thank you for all the questions, and do stay in tune for our future events in the domain of Internet Freedom Club or our other lectures on international humanitarian law and human rights in Ukraine and globally. Thank you very much.
Thank you everyone for joining. It was my pleasure.